I'm going to try and engage Justice Moshawana on this subsidiarity point in this way, if I may. If we can go to section 207 of the Constitution. My Lord, I think it's not uploaded on case lines, but we'll make sure it's uploaded in due course. I apologize for that. Now, if you look at 207 of the Constitution, and this is, remember, my Lord, this was the debate about control and manage and what all of that means. What we would submit is 207.2 can't be read in isolation from 207.1. 207.1 reads as follows. The President, as the head of the National Executive, must appoint a woman or man as the National Commissioner of the Police Service to control and manage the police service. So the person appointed must exercise some power, and what is the power they must exercise? They must exercise to either control or manage. That's 207.1. 207.2, in our interpretation, with all due respect, tells you how you exercise that power. That's why 207.2 says that the National Commissioner must exercise control and manage the police service. In other words, what 207.1 told him he can do. That's the interconnection between 207.1 and 207.2. And he does that in accordance with the national policing policy and the directions of the cabinet member responsible for policing. So, that's what the Constitution says. Now, the specific act which regulates the police service is the SAPS Act. And there are two relevant provisions of the SAPS Act. The first one is section 24 of the SAPS Act. And what section 24 says is that the minister may make regulations, and then it goes on to talk about all kinds of things that the minister may make the regulations about, but that includes things like exercise of policing powers, general management and control, labor relations, and then in particular 24G and the subparagraphs there are 8 subparagraphs, the institution and conduct of disciplinary proceedings, conduct by members that will constitute misconduct, provisions of the Criminal Procedure Act, attendance by a member or any witness at such disciplinary proceedings, the circumstances under which the disciplinary proceedings or inquiries may be conducted, the hearing or submission of the evidence at such disciplinary inquiries, competent findings and sanctions, review and appeal procedures. Now, the relationship of section 24 then, 24G in particular, says that the minister may make the regulation in respect of this disciplinary topic. And one reads section 24 together with section 40, and what section 40 of the Act says is that, and I'll quote, disciplinary proceedings. Disciplinary proceedings may be instituted in the prescribed manner against a member on account of misconduct, whether such misconduct was committed within or outside the borders of the Republic. So the point is that even though the Constitution is the foundation of the power, once the Constitution gives rise to the SAPS Act, which in turn, in terms of sections 24 and 40, gives rise to the disciplinary regulations, it's the disciplinary regulations that bind the exercise of disciplinary powers by the National Commissioner. And that's why, and now I'm going to read from the bundle of authorities, at 014-593, I don't know if someone can help guide there, 014-593, this is the Masuku judgment, quoting from My Vote Counts. I don't know, my Lord, has anyone helped you get there, or are you navigating yourself? Can someone help the charge? Direct him to 014-593? My Lord, let me try.
Made an attempt.
Is there? Okay, thank you. I'm indebted. Paragraph 102 of that judgment, where it quotes from My Vote Counts, and just listen to this with all due respect. It says, once legislation to fulfill a constitutional right exists, the Constitution's embodiment of that right is no longer the prime mechanism for its enforcement. The legislation is primary. The right in the Constitution plays only a subsidiary or supporting role. Ultimately, the effect of the principle is that it operates to ensure that disputes are determined using the specific, often more comprehensive legislation enacted to give effect to a constitutional right, preventing them from being determined by invoking the Constitution and relying on the right directly to the exclusion of the legislation. So you'll remember, my Lord, you posited to me that the National Commissioner says I'm relying on 207 and I can rely on this power to do so. It's outside the disciplinary regulations. And I say exactly. The moment the National Commissioner says he is taking himself outside the specific piece of legislation, the regulation, which is promulgated in terms of Section 40 of the SAPS Act, read with Section 24 of the SAPS Act, which gives effect to Section 207 of the Constitution, the National Commissioner is no longer allowed to do that. And the effect of that, my Lord, is that if that regulation does not create a stay-at-home power, then, with all due respect, the debate ends because that's an exercise of power by the National Commissioner that he does not have. Let me illustrate this, if I may please, with respect to a judgment that is cited by our learned friends. It's a judgment called South African Police Union versus Minister of Police and others. And I just want to highlight a few paragraphs in that judgment. This is a judgment relied on by my learned friend's client. If you go to 014-731, that's 014-731, paragraph 79, this court said, Section 40 of the SAPS Act provides that the National Commissioner and employer may institute disciplinary action against any employee who commits misconduct. The prescribed manner is set out in the disciplinary regulations discussed above. So, the point here is that not only does the principle of subsidiarity tell you that the way to approach this disciplinary issue is via the regulations and not the Constitution, this court itself has endorsed that the regulations are the principal instrument through which you establish whether the power exists or doesn't exist. So if you turn back by one page, 014-730, what you'll see, and this Justice Davis takes us back to something we were discussing earlier, para 66 of that judgment, it says, it is the National Commissioner's prerogative as the employer to initiate investigations and disciplinary action. Then it says at paragraph 69, the National Commissioner has the power to suspend in accordance with the entitlement to do so in terms of Section 40 of the SAPS Act, read with regulations 4, 5, 8, and 10 of the disciplinary regulations. And then it goes on to say, you will see at paragraph 70, there's a concession made by counsel in that matter that the relevant employees were indeed members of the SAPS Act. That's still on 014-730, paragraph 70. But then if you go over the page again to where we started, at 014-731, you'll see that the conclusion reached in 78 doesn't apply here in this matter, because in 78 what it says is, it says from the papers, it is clear that all the legal prescripts have been met for the lawful suspension, pending the internal disciplinary process. But as we've just been debating, if there's no power in terms of the disciplinary regulation, you can't then invent that power having regard to Section 207. The only instrument that regulates discipline in the police is, with all due respect, the disciplinary regs, and if there's no power to stay at home there, well then you can't give an order to anyone to stay at home. So let's go back then, before the tea break, we were discussing SS1 at 001-58, and you'll remember I'm still addressing you on the power and whether or not there's a power to order the stay-at-home order or to give the stay-at-home order. Now you'll see that at 001-58, paragraph 1, we read this out earlier, so I'm not going to spend much time on it, but you'll know that this notice is purportedly in terms of Regulation 8.1. Now, if you keep one finger there, and if you go to 001-96, which is in the regulations, towards the bottom of the page, what it says is the following. It says, at 8.1, a supervisor must ensure that the investigation is completed within 30 days, and if satisfied that the alleged misconduct is of a serious nature, the holding of a disciplinary hearing, refer the outcome of the investigation to the employer representative within 7 working days to initiate a disciplinary action. The employee must be informed of the alleged misconduct and pending investigation. And then 8.2 on that same page says, the employer representative must within 15 working days charge the employee with misconduct by serving a written notice to attend a disciplinary hearing in the form determined by the National Commissioner. And if you carry on reading Regulation 8, the point, let's actually do that at 001-97, Regulation 8.3, Regulation 8.3 talks about the written notice of the disciplinary hearing. And it says what the notice of the disciplinary hearing must contain. It does so at subparagraphs A to D. And then sub 4 and 5 talk about service. Now, why do I take you to that? I take you to that because what we know is that after SS1 is given to Lieutenant General Sibiya, the stay-at-home order emerges. And the stay-at-home order keeps him at home pending whatever investigation is said to be happening or not happening. So the first point is that this stay-at-home order is self-evidently not authorized by Regulation 8, because Regulation 8 doesn't permit the National Commissioner to issue such an order, even where there are allegations of serious misconduct. That's point number 1. Point number 2, and this takes me back to the debate that Justice Davis and I were having, and in fact, I'm grateful to Justice Davis because he posited a number of qualifications at me. He said, did General Sibiya get paid? Did he have security? And so on. And the conclusion there was reached that, well, then isn't that a precautionary suspension? Now, if that is the case, if it is a precautionary suspension, and then the long principles apply which might clothe the National Commissioner's powers with some degree of lawfulness, let's look at what the regulation itself says. If you go to 001-99, this is again back in the disciplinary regulations. Does the court have it? I'm getting indications, I'm indebted. Halfway on that page, 001-99, suspension. A suspension or temporary transfer is a precautionary measure. So this is, Justice Davis, the debate we were having earlier. But look very importantly what it says at 10.2. The National, Provincial or Divisional Commissioner may suspend or temporarily transfer an employee provided that before effecting such a suspension or transfer, such an employee is afforded a reasonable opportunity to make written representations. So if you just stop there, and we accept, Justice Davis, having regard to the debate you and I had earlier, that the National Commissioner does have a power of precautionary suspension. What we know is that 10.2 sets out the requirements it has to meet before that power is lawful and can be effected. And if you measure 10.2 against what we just spoke about in SS1 and SS2, you will see that there is absolutely no provision for Lieutenant General Sibiya to make any submissions whatsoever. Because what happens with SS1 is he just gets told about the alleged misconduct, and SS2 is that he's told to stay at home. So, if it is a precautionary suspension, well then it's dead in the water because it doesn't comply with Regulation 10.2. I've just shown you that. But if it's not a precautionary suspension, it's still dead in the water, because Regulation 10.2 is the only thing that regulates staying at home or suspension or not coming to work. And so if there's no power to order such a stay-at-home order, then the point to be made is that it doesn't comply with 10.2 as a precautionary suspension. And worse still, even if there is full remuneration and all those kinds of things as discussed in 10.3, the employer can only make that decision after having afforded the employee a reasonable opportunity to make written representations. So that's the dilemma that Lieutenant General Sibiya finds himself in. When SS1 comes about, it's told that you're being informed about these allegations. All right, fine, we're informed about those allegations. But then the very next thing on the same day is SS2, which says stay at home. And there's nowhere in the regulations that says that the National Commissioner is allowed to tell anybody to stay at home. The closest the stay-at-home order comes from is Regulation 10, and I've demonstrated to you how, on any interpretation, the stay-at-home order can never meet the requirements of 10.2 because there was no opportunity to make representations. And worse still for the National Commissioner, because of what I read out to you from Masuku, and because of how I've explained the principle of subsidiarity and the interrelationship between 207 of the Constitution, 24 and 40 of the SAPS Act, and the disciplinary regs, the National Commissioner is not allowed to go back to the Constitution and invent a power that the specific regulation does not give him. So insofar as the stay-at-home order is concerned, and I'm only limiting myself to the stay-at-home order for the time being, that is unlawful. And it's unlawful because of a simple non-compliance. Simple non-compliance. So that's where we are. Now, if the court then has regard to, still in the disciplinary regulations, if I may, 001-93, this is Regulation 5. No, I lie. 6. Disciplinary officers. 6. 001-93, my lady presiding. And the particular regulation I'm looking at on that page is Regulation 6, headed disciplinary officers. Now, all I want to point out here is that what we are told by General Masemola is that he appointed someone as an investigation officer, General Patekile, and that General Patekile was an investigation officer and he performed some or other investigation. We don't know what the outcome of that investigation is. It's not on the papers. So the first point I would make is, if the investigation is concluded, what's the point of a precautionary suspension in circumstances where the very thing you're trying to protect on the respondent's version has already been done? There's no purpose to continue with the stay-at-home order in whatever manner it's described, stay-at-home or anything else, because the investigation has concluded. And if we applied the principle of Long versus SA Breweries, keeping Lieutenant General Sibiya at home whilst the investigation has concluded then converts an otherwise precautionary suspension into a punitive suspension. And that would also then be unlawful, having regard not only to the fact that it would be the use of a precautionary suspension power for an ulterior purpose, it would also be ultra vires Regulation 10. So the spaghetti, the procedural spaghetti that our learned friend's client has tied himself into is what we're pointing out here is the breach of General Sibiya's rights. And at the very least, that entitles General Sibiya to prayer 2 of the notice of motion, which is to set aside the stay-at-home order as not being authorized in law. And I don't want to repeat myself from earlier, but that's why the authority relied upon by our learned friend in freedom under law is in fact against him, not in favor of him. Because what freedom under law emphasizes is that the SAP's commissioner's powers is limited by the discipline regulations. That's at paragraph 218 at 014-202. The court doesn't need to go there, I read it out earlier. I'm just re-emphasizing the point that all the authorities tell you that it's only the regulations. And the commissioner himself says, well, I acted outside of them. Game over, with all due respect. If the very repository of the power says I acted outside the terms of the enabling instrument in terms of which I exercise public power, that's ipso facto unlawful. That's affordable medicines, that's pharmaceutical manufacturers, that's all of those cases we discussed earlier. So that's why prayer 2 of the notice of motion falls to be granted. Whilst I'm on that stay-at-home order, some gizmo has fallen down here from the media. I don't know what that is, but anyway. Whilst I'm on that stay-at-home order, let's just test the logic of what the National Commissioner says. And I want to adopt then the National Commissioner's logic that he is entitled to give the stay-at-home order. Let's just assume he has that power. What does that mean? Well, then it means that the content of Regulation 10 would be rendered redundant, because every precautionary suspension could be labeled as a stay-at-home order, and all of the protections that are afforded to employees in terms of Regulation 10 would be taken away merely because the National Commissioner says, well, I'm not giving you a precautionary suspension, even though, Justice Davis, your stay at home is with pay, it's with your security, it's with your full benefits, which, by the way, sounds like a precautionary suspension.
No, the contrary. For considering a precautionary suspension, those elements might be considered by the person issuing it.
Agreed.
Here, there is no such consideration. There is no impairment on any of the pre-existing remunerative provisions. It was just staying away from your office.
But this is the point that I'm making, is that if you are willing to accept that distinction, with all due respect, you're accepting form above substance. Because what that stay-at-home order does, apart from the fact that it ticks similar boxes to a legitimate precautionary suspension, like we were discussing earlier, like you've just posited to me, pay, remuneration, security, conditions of employment type of things. If that is the case, then the fact that, apart from the fact that there's no such thing in the regulation, it means that Regulation 10 would be pointless. And you know that the approach to statutory interpretation is that you never interpret towards redundancy. You always interpret towards having effect. And if that is the case, then you'd have to ask yourself, why is it that a stay-at-home order, which looks like a precautionary suspension, smells like a precautionary suspension, probably for General Sibiya even tastes like a prescripts of Reg 10. And if it is then taken outside the prescripts of Reg 10, then it's unlawful, because there's no statutory basis upon which a stay-at-home order can be issued, particularly where the effect of that stay-at-home order is indistinguishable from a precautionary suspension, because, as the applicant says, the stay-at-home suspension, the stay-at-home order is effectively a precautionary suspension by another name. That's the point. And so if there's no legal authority for that, that decision then falls to the wayside. Whilst I'm on that, can I just say that there's a dispute between the parties about, there's a dispute between whether General Sibiya does have a security or doesn't have security. Is he being provided with resources? Is he not being provided with the resources? May I just give the court one reference, if I may? We don't dispute the fact that he's got full remuneration, but you know that the security issue is an issue that is in dispute between the parties. what you will know from the record is that, and if you'll bear with me, here we are. You know that in the founding affidavit at 001-52, paras 211 to 214, Major General Sibiya says that the risk assessment confirms the high threat on his life and recommends that he be afforded static and transit protection, and he goes on to say that he was not afforded that. What the National Commissioner says in response to that at 003-49, all the way up to 003-51, paragraph 41.4 to paragraph 42.8, is he says that the National Commissioner ordered that Sibiya be provided static and transit security, and a team was deployed, but Sibiya withdrew the team because he was unhappy with the selection. And then what you know in the replying affidavit, having regard to the risk assessment, is at 004-60 at 251, para 251 to para 254. Sibiya says, given the sensitivity, he asked that he would be able to choose his security because he can trust them, and given that there is hostility inside and outside the SAPS towards him, and more than that, that on 31 July 2025, the SAPS itself prepared an information note recommending that Sibiya be allowed to choose the team he trusts. Now, the reason I advance that in front of you is because, again, to the extent that this stay-at-home order is a disguised precautionary suspension, that depreciation in benefit, pre being made to stay at home and post being made to stay at home, is an unlawful consequence of an unlawful decision. And we say that because there's no statutory authority for that decision, that adds further credence as to why it should be reviewed and set aside or declared unlawful, as the case may be. Now, if I may then move on to paragraph 3 and 4 of the notice of motion. That's the interdict and the alternative suspension prayer. Let's start at the beginning. And the beginning, what I have to say about in the beginning is this. At 001-63, the terms of reference for the Commission say the following. The Commission is appointed to investigate and report on the veracity, scope, and the extent of the allegations with regard to the infiltration of law enforcement, intelligence, and associated institutions within the criminal justice system by criminal syndicates, and here's the important part, and make findings and recommendations for criminal prosecution, disciplinary action, and institutional reform. Now, why that's the important starting point is, you'll remember in the morning when we were debating, particularly between Justice Moshawana and myself, as well as Justice Davis and myself, we were trying to tease out what's the interrelationship between a parallel disciplinary process and the Commission. I'm going to leave aside the lack of powers for the time being. I've dealt with that argument. I'm not going to repeat myself. Let's just move on now to the interrelationship between the two. This is the point. The point is that insofar as prayers 3 and 4 is concerned, the attack on the National Commissioner's insistence on disciplining, at this stage at least, is not to invalidate for a rule of law reason or to say that it was unlawfully taken or whatever. That's actually not being challenged in front of you. What the relevance is that in a situation where my client, Lieutenant General Sibiya, faces two processes, one under General Masemola and one under the Commission, He comes to the court and he says, I'm not asking you to invalidate what Masemola is doing or not doing insofar as the institution of the investigation is concerned. For that disciplinary process, which was either previously started or this new one in terms of the Section 10 notice that we debated earlier, I'm asking you to interdict it. And I'm asking you to interdict it because it is a breach of my rights. And where he says it's the breach of his rights from is that it comes from inter alia, the issue about the conflict, the issue about the double jeopardy, the issue about conflict, double jeopardy, the further issue about whether or not it's an abuse of process, and all those other kinds of allegations which are on the papers. Now, why that's important is because when the court comes to consider the interdict prayer, unlike in prayer 2, it's not being asked to make a final determination on lawfulness of the institution decision. It's not being asked to do that. It's being asked to grant an interdict in circumstances where it can be demonstrated that if the process under General Masemola is allowed to continue, it will have a prejudicial effect on General Sibiya's rights. And in that scenario, rather than let that process go ahead, stop that process and let the Commission, who doesn't suffer from all of the problems that General Sibiya says General Masemola suffers from, let them do that. And because the Commission has the power to make recommendations on disciplinary action and all those kinds of things, the point to be made is that the Commission is the more appropriate forum. So the interdict prayer is different to the prayer in prayer 2. The prayer in prayer 2 is a final prayer on a rule of law challenge type point, ultra vires. Prayer 3 and prayer 4 is asking this court to exercise its discretion about whether or not it issues an injunction or doesn't issue an injunction. And that's why when I started in the morning and I said, you know that the test is prima facie open to some doubt, that's what General Sibiya has done. 3 interdependent reasons which demonstrate that if the Masemola process is allowed to continue, his rights are going to be prejudiced. This court might not agree. This court might think, well, you know, I'm not convinced and whatever, but that's not the test. The test is, even if open to some doubt, is there an infringement to the prima facie right? And if you accept that an employee at first principles is entitled to a lawful disciplinary process, and then what is placed in issue is the very lawfulness of that disciplinary process, even if this court is not convinced, the fact that the existence of that prima facie right, though open to some doubt in front of the court, is what triggers the interdictory relief. And that's what we say is the fundamental difference between prayers 2 and 3, and why, however, flowing from prayer 2, prayer 3 can, in fact, be granted. And I would like to, if I may, just go to one of the authorities that my learned friend's client relies upon. It's the Minister of Police Authority versus Premier of the Western Cape. And I want to draw attention to paragraph 54 of that judgment, which can be found, if I'm not mistaken, at 014-149. 014-149. And let's just look at what paragraph 54 says. We need to examine this together because remember, what prayer 3 and prayer 4 is asking this court to do is it's asking the court to exercise a discretion about which disciplinary process should be given the opportunity to run. And what our learned friends say is that, well, these two things can operate side by side, and because they can operate side by side, there's no basis for the interdict. But look at how the court, the constitutional court, reconciles these two things together. It says, and this was, and I'll admit this was in the context of a subpoena, but it says the following, and I'm reading about 3 lines down in that paragraph, 4 lines down in that paragraph. Even if a police witness were to appear in person, ordinarily it would be over a limited time. Secondly, the mere attendance of the police at a hearing cannot possibly usurp the general management and control of the police service and their day-to-day activities. When required to testify before a commission, a police officer may raise any lawful objection to the production of particular evidence. It is trite that a subpoena issued by a commission must be lawful. It may not travel beyond the mandate of the commission or be otherwise defective. If it were so, it would be open to the police service to have it set aside. So let's just pause there. How that's relevant to this dispute is that the Constitutional Court tells you is that a commission and the general power can exist side by side, and that where the commission does exist, it can act within the scope of its mandate. And what we know is that this commission's scope of its mandate includes disciplinary action. And so even though the National Commissioner may still retain, in theory, a power to discipline, the question the court has to ask itself is, would allowing that process to continue advance the law or retard the law? And we would say that in the context of these specific facts, where the very person who is in some way sitting in judgment of Lieutenant General Sibiya is also himself implicated in the potentially implicated, in the very wrongdoing that is relied upon by that individual, General Masemola, to suspend or make him stay at home, General Sibiya, that surely cannot be an advancement of the law in this situation. And what's important about this is to remember that we're not asking that all disciplinary action against Lieutenant General Sibiya fall to the wayside. It's very specific. It's saying it's only those disciplinary issues that run concurrently with the terms of reference of the Commission of Inquiry. And what does that do? That does two things with all due respect. One is it preserves a process that allows Lieutenant General Sibiya to be disciplined in respect of the Mkwanazi allegations by an independent, neutral arbiter, being Justice Madlanga and advocates Baloy SC and Kumalo SC, who are not themselves implicated in making these kinds of decisions, potentially implicated in making these kinds of decisions. But what does it also do? It also allows Major General, I think he's Major General, the National Commissioner, General Masemola. It allows him to discipline potentially Lieutenant General Sibiya for all kinds of other issues that fall outside the terms of the Commission of Inquiry, and the interdict only serves as a small break on his otherwise full set of powers, and the reason for the small break on that otherwise full set of powers is as addressed in the papers, because the Commission is the more appropriate body to do so. I'm not going to read the authorities, you will know them, but there are ample authorities that talk about the doctrine of nemo iodex in sua causa, where no party may sit in judgment of themselves. In our heads of argument, we make reference to the Liebenberg judgment, paragraph 55. And in fact, maybe I should read it out, because this adds the context as to why the interdict is important. It says, the very idea of adjudication, and you will remember General Masemola is adjudicating to an extent my client, at least in the preliminary stages. The very idea of adjudication connotes impartiality, for the integrity of justice is threatened as soon as self-interest, actual or probable, in the mind of the person adjudicating is tolerated. And that's the very point we're saying here. We're not asking this court to say he is conflicted. We're not asking this court to say he's not conflicted. We're saying if the court can say that Major General Sibiya has laid out a factual basis for a reasonable perception of conflict, then that would violate the principle articulated in Liebenberg. And that's the point that we are saying. The judgment went on to say that so strict are the courts that even where justice would seem to have been done by persons unaffected by bias, yet the mere presence at their consultation of a non-impartial official will vitiate the proceedings. So in other words, what the authorities tell us is that when someone is going to be disciplining another, it's not actual bias that necessarily excludes them, but it's a low bar, in the words of the court here, where the mere presence of a non-impartial official will vitiate the proceedings. And it cannot be doubted that given the factual contest between General Sibiya and General Masemola, which will be resolved elsewhere, not in this court, that is sufficient conflict for the purpose of the interdict, because otherwise, if General Masemola is allowed to be both the complainant, the prosecutor, the decider, and the potential appeal body, that vitiates the proceedings in the way in which we complain about here. And as you will know, the exhaustion of the court is, justice must not only be done, but it should manifestly and undoubtedly be seen to be done. And we say to you that justice would not be seen to be done in these circumstances if the very person potentially implicated in these situations is allowed to take disciplinary action against my client. So that's the reason that prayers 3 and 4 fall to be granted in favor of my client. Can I just give some authority as further support for this? Because what you'll remember, or maybe this is the argument, let's just say the court is against me and doesn't grant the interdict, or the court chooses not to suspend. Then what my client would be forced to do is he would be forced to review potentially in due course and undo the illegality that he complains about. But what we know is that the Constitutional Court has said that that sometimes is too little too late. At 014-252 in the Glenister judgment, penned by then DCJ Moseneke and then Justice Cameron, in the context of IPID, some of the members of the court might be familiar with this, but in the context of setting up setting up the Hawks, the DPCI. So we're talking about very serious criminal justice issues. The court said, in short, and I'm reading from para 247, in short, an ex post facto review, rather than insisting on a structure that ab initio prevents interference, has, in our view, very serious and obvious limitations. In some cases, irreparable harm may have been caused, which judicial review and complaints can do little to remedy. And so the point we make is that by Lieutenant General Sibiya coming to the court and asking for the interdict, alternatively the suspension prayer, he's forcing, in effect, under the authority of the court, that whatever disciplinary action is going to be taken against him is a lawful disciplinary action or a more lawful disciplinary action ab initio. Because if he were forced to be subjected to a disciplinary proceeding that was subsequently found to be unlawful, the harm and the damage is too little, too late, based on the strength of what the court says in Glenister. And that, with all due respect, is something that can't really be overlooked. And this is not surprising, because what the court will know is that that obviously deals with the interdict standard. Prima facie, right, though open to some doubt. But the court has developed its jurisprudence. In this court, if I'm not mistaken, it was our current acting Deputy Judge President sitting as the High Court alone in the matter of Gordon versus the Public Protector. If you'll bear with me. Here we are. Gordon versus the Public Protector. In the context of disciplinary proceedings, because you remember the Public Protector's recommendation in that matter is that Minister Gordon must be subject to disciplinary proceedings. Minister Gordon then brought the interdict and the dispute in front of Justice Molopa Setosa, our current acting deputy judge president, is whether or not the interdict should be granted. And when the interdict was being disputed, then Minister Godon, now the late Minister Godon, had filed a review application, and prima facie in the interdict relied on the issues canvassed in the review to establish his prima facie right for the purposes of the interdict. And look at what Justice Molopa Setosa says. She says, the harm to Godon speaks for itself. The harm would be irreparable if the interdict is not granted. Being prosecuted, disciplined, and investigated most certainly constitutes harm, and the harm may be irreparable and irreversible by the time the review application is heard, especially so if the review application is successful. The judge went on to say, there is no harm to the public protector or her office if the remedial action is suspended pending the review. This is not a final order, and if the review is to be unsuccessful, the remedial actions are to commence. This matter constitutes a clear case where judicial interference is warranted. The public protector and her office can fulfill her constitutional duties with the suspension order not interfering with them. Suspension of her orders has most certainly not interfered with her constitutional duties in other matters. The mere fact that the parties have abided to the court decision is not an acquiescence to the remedial orders of the public protector. So how does that apply here? What Justice Molopa Setosa says is that when you are subjected to the review, or when you are subjected to the disciplinary action which is going to be challenged in the review, if the review is successful, well, then you should never have been subjected to that in the first place, self-evidently. But what she says is if the review is unsuccessful, well, then you can do your disciplinary conduct whenever the review is dismissed. Applying that logic to this case here means that the interdict, with all due respect, should be granted, because we say there are serious questions about the lawful ability of Masemola to be involved with all of that, and that's why the commission is the more appropriate body. And it's actually even better than the situation than Minister Godon, because you'll remember in Minister Godon's case, the issue was no remedial action, wait until the review outcome, then decide what to do. Here, it's actually better in the favor of the SAPS, because we're not saying hold off the disciplinary action forever. We're just saying you, National Commissioner, don't take the disciplinary action, let the Commission of Inquiry do it. And so if there's any allegation of harm that the National Commissioner himself or the police as an institution lose an ability to discipline a member of theirs, that's actually not true, because the Commission will plug the gap. And if the Commission then decides that there's nothing for General Sibiya to answer for, nothing prevents General Masemola at that stage to try discipline again. But the point of the matter is that in this phase of the initial discipline, the question the court has to ask is whether or not it should permit my client to be subject to a disciplinary process where there's the question of inter alia, the conflict of one of the principal decision makers involved in making these decisions against him. And look at what and remember the Godon matter was taken on appeal to the Constitutional Court. You'll remember that. And in the minority concurring judgment of Justice Jafta, as he was then, in which all the members of the court concluded, the court said this. I'm reading from para 113, which can be found in our bundle of authorities. Someone will give me the reference to the bundle of authorities. But at para 113 of that judgment, and I'm reading about midway in that judgment, the court said this, and this is why it's important to bear in mind that prayers 3 and 4 are pleaded in the alternative to each other. Even if it could be said that there were prospects against the grant of an interdict, in other words, you're not with me on prayer 3, the applicants for leave would still be faced with the question whether there were prospects against suspension. Requirements for suspension differ from those needed for an interim interdict. The outer standard, and you'll know our learned friends try to argue both outer and setlogelo against us in the context of the interdict, which is fine. We say we come home on the interdict standard anyway for the reasons that I've addressed. But the court said the outer standard does not apply to suspension. The court goes on. The power to suspend the operation of the public protector's remedial action is sourced from section 1721B of the Constitution. If in a matter like the present, it is considered just and equitable to suspend a remedial action pending a determination of the review in which the validity of the remedial action is impugned, a court may grant the suspension. Guidance for issuing the suspension is derived from considerations of justice and equity. And that's why the court is being asked in the alternative, an interdict or suspension, is it in the interest of justice to subject General Sibiya to this kind of disciplinary process for all the reasons we say he shouldn't to, and where the Commission can plug the lacuna? The court went on to say at para 115 of that judgment, a determination of just and equitable order of necessity requires a careful consideration of interests of parties on both sides of the litigation. The order must be fair and just when all relevant factors are taken into account. What is just and equitable in a given case depends on the fact. The argument becomes potentially arbitrariness, capriciousness, abuse of process, mala fide, and so on. Okay, and we're not saying that is what General Masemola wants to do. We're giving him the benefit of the doubt. So if we give him the benefit of the doubt, and the effect of his disciplinary conduct is to achieve a disciplinary outcome, why is it not in the interests of justice and equity to allow the Commission to undertake that disciplinary conduct in circumstances where there are questions over General Masemola's ability, capability, and lawful standing to do so? What you'll know from that Godin judgment is the Godin judgment was emphatic to say, don't allow the exercise of a public power purely for the sake of expediency. In other words, exercising that power for the sake of exercising that power. The court is enjoined to take a more interrogative approach as to whether or not the exercise of that public power in the circumstances would constitute something that could be defensible in the interests of justice. And what we say to the court is that we are not in that territory at all, for all the reasons that I've advanced in front of you. And that if General Masemola's disciplinary process is allowed to go ahead, then we're going to be setting ourselves up for a review in due course, irreparable harm, too little too late, contradict Glenister, contradict Godin High Court, contradict Godin Constitutional Court. Really, what are we doing here in the first place? And so we'd say with all due respect, that's something that this court should not permit to go ahead. Let me talk about the evidence, if I may. I'd like the court, please, to go, because we were talking about the answering affidavit earlier, and I think maybe it's time for us to do a little bit of digging in the answering affidavit. If the court goes to 003-33, paragraph 23.2, look at what he says. I am mandated in section 207 of the Constitution to control and manage the police, and then he goes on to say, in line with national policing policy and directions from the Minister of Police. So that statement tells you he recognizes the importance of the disciplinary regulations, but that to justify his power, he says he can go behind all of that to 207.2 and sidestep that very same disciplinary regulation to achieve the effective precautionary suspension, which he styles as a stay-at-home. That obviously is not lawful and is something that should be placed in doubt when the court considers this. If the court turns over at 003-34, paragraph 23.6 of the answering affidavit, look at what he says. I appointed an investigation officer, Lieutenant General Patakile, to conduct a preliminary investigation.
Not to interrupt you, but we've read the papers. We'd like you to advance and possibly also conclude your argument.
May I make 3 brief submissions on that paragraph then that I was referring to? In the first instance, there's no such thing as an investigation officer. Go read the regulation. In the second instance, the only disciplinary power that is permitted is a disciplinary officer. That's Regulation 6. The paragraph refers to Regulation 8.1. Thirdly, insofar as the absence of the employee is concerned, that's confirmed. that we say is supportive of our case. So if I don't have to read the paragraph, which I'm grateful for, the legal points stand in the way that they do from the papers, in the way that I've mentioned them. Urgency. 3 cases, if I may.
That's not an issue. The matter started out as an urgent application at the request of your client. A special court was constituted to continue that urgent application, which is now dealing with. Matters of national interest are involved, and we're...
But I really did not object the matter in relation to the urgency.
That's different to what was indicated previously. So I'm happy that urgency is no longer in doubt. Eastrock, Apleni, and Letso Honyane stand in my favor. No substantial redress in due course, rule of law harm, and contractual performance of contractual remedy of specific performance. Costs. Simply put, we say that given the absence of lawful authority for the decision taken under prayer 2 of the notice of motion, that concedes the case. My client is entitled to costs there. In the instance where the resistance by the National Commissioner for Prayers 3 and 4 is not grounded in cognizable legal principle for the reasons that I've articulated, we say that the insistence of the National Commissioner to want to discipline in these circumstances is for the purposes of expediency, which has been sanctioned by no less than the Constitutional Court. And given the extent to which the National Commissioner, rather than exercising his duty as stated in Kurland, where state litigants have a higher duty to be careful about how they litigate at the state's expense, particularly on rule of law issues, which this court will know comes from another judgment of the Supreme Court of Appeal in Gauteng Gambling Board, and then also the Constitutional Court in Public Protector versus the Saab, that in those instances costs should be awarded, punitive costs should be awarded, and you'll know on the papers we make a case as for personal costs against General Masemola. However, we accept that this is the urgent court. If the question of costs is going to be an issue that can always be determined at a later stage, in due course, that question should not detain the court. But if the court is willing to give a cost order, we say we're entitled to costs on the scale sought. And what we also say is that in the event that the court is not with us on the merits, we're immunized because of BioWatch, and this is quite clearly constitutional litigation because it's testing powers under the regulation and subsequent disciplinary powers. May I take an instruction? Thank you.
His previous attorneys tried to stop this thing before it happened on the 11th of July, where he asked the police to respond to these allegations before they take any decisions. It's page 001-26.
Just two notes, if I may. The first one, if I can ask the court to please have regard to what is said at 001-26, which is in the founding affidavit, and at paragraphs 83 onwards of that founding affidavit, what you will know is that as far back as the 11th of July 2025, which is several days before these notices came out, SS1 and SS2, my client, General Sibiya, said, don't do this to me, and if you're going to do it to me, at least give me an opportunity to make representations before you act against me. That was then not responded to, or it was responded to late, and no opportunity to make representations was afforded. And that, with all due respect, compounds the unlawfulness that I spoke about earlier in the context of how you read regs 6, 8, and 10. That's the first point. The second point, if I may, is just to point out something to the court regarding the first supplementary affidavit, which I understand has been admitted into evidence. If we can please go to that first supplementary affidavit. What? 9-2. Okay. I'm indebted to my learned attorney. The application to introduce starts at 9.2. I want to go to the affidavit itself, which starts at 009-6. That's the covering page. Over the page at 009-7, what the applicant tells you is that there's a new document that's called a Notice of Intended Suspension in terms of 10.2. He discusses the notice at paragraph 5 at the bottom of that page. But very importantly, at 009-8 in that affidavit, from paragraph 8 onwards, and this goes all the way from paragraph 8 on that page to paragraph 11 at page 009-11. What the applicant tells you is that, and you'll know this because you've read the papers, is that there's a fundamental disjunct between SS1 and SS2, because that's all predicated on the Mkhwanazi allegations. And then suddenly, in the middle of these proceedings, after the launch of these proceedings, after even the filing of the replying affidavit, if I'm not mistaken, this notice emerges, and this notice makes out an entirely new case that General Sibiya is apparently going to be disciplined for in respect of Reg 10, and that's the non-compliance with the instructions. Let me pause here. What you know is that General Sibiya is at pains to demonstrate how he complied with General Masemola's instructions, how he produced the dockets plan in coordination with General Rabi, who is an official from General Masemola's office. You know all of those factual averments from the founding affidavit regarding General Sibiya's compliance with what he says was General Masemola's instructions. Okay, if the court doesn't even want to go there, the mere fact that there is a disjunct between this new notice that emerges out of nowhere and then the earlier notices which somehow purport to be in terms of Reg 8 and giving effect to a stay-at-home order demonstrates at least one of three things. Either this notice is too little too late and it's trying to plug the gap that was identified in the pleadings earlier, or it's a duplicative attempt to now ensure that all General Masemola's bases are covered and he's disciplining General Sibiya on every conceptual notion whatsoever. And you'll know that the challenge there we raise is both in respect of prayers 2 and 3 and 4 for the interdict. Or, at the very least, there's a trial prejudice happening here. And that every time my client, General Sibiya, attempts to draw a line in the sand and protect himself, the response come hither from General Masemola is, well, now it's no longer about this, it's now about that. And so if you draw a golden line between SS1 in the founding affidavit and this annexure, or annexure SA1, in the first supplementary affidavit, which is at 009-18, if I'm not mistaken, you'll see that that trial prejudice occurs. And that includes, by the way, Justice Davis, the issue that you and I were debating earlier about the introduction of those reasons for the alleged stay-at-home order in the answering affidavit, which wasn't present in the notice when it was filed at the time. So on any conception, we say that with all due respect, we come home on prayer 2, which is the prayer to quash the disciplinary decision. And then furthermore, we come home with all due respect on prayer 3 and 4, which is the pending the Judicial Commission of Inquiry prayers, either to interdict such parallel proceedings, fresh ones or ongoing ones, or alternatively in prayer 4, to suspend those that have already been taken but are in the process of implementation. I'm indebted to the court for giving me as much time as it has, and I look forward to the reply.
Please sit down, Mr. You would have noted that since the tea adjournment, we allowed you to develop all your arguments as fully as you wished. And we thank you for the oral argument in addition to the heads. On one aspect, I just still need some clarity.
Yes, Judge?
The argument that you put forward in answer to my learned brother's question about the intersect of the work of the Commission and the disciplinary procedure for having allegedly not complied with an order
Yes.
regarding the dockets. Refresh my memory. When you started referring to evidence, I did interrupt you, but you were on a different topic. What is your client's evidence? What does he say should happen with 121 murder dockets while the Commission continues for an indefinite period?
I'm not sure that he has to say anything about that. Does he?
Well, that's not the question. My question was, what does he say? If your answer is he doesn't say anything, that's an answer.
No, I think with all due respect, we're speaking cross purposes with each other. I'm trying to understand. I'm trying to understand the scope of the in-question. Is the question, what does he say happened with the 121 dockets, or what should happen?
What is they should happen? You say he didn't say anything.
That's why I asked the question.
Yes.
What is he supposed to say?
Well, the National Commissioner says whatever happened to the ministerial task team, the dockets should continue to be investigated, murder should continue to be investigated, witnesses should be protected, and investigative procedures should be continued. And that's why, in a failing-out fashion, failing-in fashion, the docket should be returned to the station and be continued with. And that is why he objected to them being collected and taken to head office. And that's the basis of the charges put for the suspension notice.
Okay.
And you said, well, don't do a suspension notice issue because it will intersect with the Commission. My question is, what does he say then should happen with those documents, and how does that intersect with the Commission's work? About historical facts.
With all due respect, I'm struggling to understand the question, because let's just understand. I'm sorry, my lord, must I respond to you or must I not respond to you now? I'm not sure what you want me to do.
Mr. President, generally counsel responds to a question.
Yes, so may I please do so, because I was trying to do that. What I was going to say to you, my lord, starting out from first bases, is that this disciplinary issue and what happens with the dockets or doesn't happen with the dockets resulted in an order for my client to be told to stay at home. The effect of being told to stay at home, one would imagine, is that he cannot do anything operationally whilst that continues. So to the extent that there is a question asked about what he should be doing, my response is I'm not sure that he can be saying anything about what should be happening with those dockets, because he's currently at home and outside the operational remit of what he might otherwise had. But I'm being whispered at.
Yes, I think you're avoiding the question.
No, with all due respect, I don't think I'm avoiding the question. I'm trying to answer the question. Yes, I apologize. Forgive me, Justice Davis.
Sister asked me to paraphrase the question. Let's make it simple.
Please.
The accusation is the Commissioner said, here is the plan, the docket should go back to the stations. Investigations should continue. The accusation is your client gave an instruction that all those dockets should be retained and go to the Divisional Commissioner, Detective and Forensic Services. That's contrary to the National Commissioner's instruction. That's the basis for the disciplinary.
Yes.
Now you say, no, stop all these procedures pending the Commission's work because they intersect. Now my question is, in what way does it intersect if the Commission has to see whether there was interference previously in the investigations or in the dockets? How does that intersect with the instruction carry on in future?
Oh, I finally understand the question. Thank you, Justice Davis. I'm so glad for you having paraphrased it in the way. The answer I give is the answer I mentioned earlier about the about the terms of reference for the Commission of Inquiry. You'll remember what I said is that the specific mandate of the Commission was about disciplinary actions, and one of those specified issues about the disciplinary actions is what was done with the 121 dockets. So, to the extent that there's the intersect, that subject matter will come before the Commission, and if it's found that Major General Sibiya, Lieutenant General Sibiya, has conducted himself in a manner that is worthy of disciplinary sanction, then the Commission will discipline him. Yes. Yes. The investigation of how... I'm sorry, my lady presiding, could you repeat that? No, so I think now, thank you, my lady presiding, I appreciate that. The Commission is not going to be investigating the dockets. They're not going to be doing police work. What they are going to be doing is looking at the conduct of the officials in carrying out orders or not carrying out orders, and evaluating that conduct and deciding whether that's worthy of disciplinary sanction or not worthy of disciplinary sanction. That's what the Commission is going to do. Insofar as what my lady presiding says to me about ordinary police work is concerned, in respect of those dockets, that's something which at the very least falls outside, I would suggest, the remit of my client, certainly whilst he's at home. And insofar as what must happen with those dockets on the advancement of ordinary police work, the relevant officials must take their decisions. With all due respect, I think the difficulty is that my client's version is what it is about his conduct in respect of those dockets, and that is what will be evaluated by the Commission. But what happens with those dockets themselves and what police work is done is a different, is something that doesn't apply. The intersect is about the disciplinary action that may or may not be taken as a result. I'm just being whispered at, if I may.
Being motion proceedings, would we be worried or should we be worried about the applicability of the plasma event test, or we should, given this dispute?
Yes. Well, can I say that that's not a factual inquiry. That's a legal inquiry. That's the inquiry you are engaging in asking me about the source of the power issue, is does the relevant instrument give the power or not give the power? And that's I'm coming to the answer, if I may. That's the legal engagement on the topic. Insofar as the application of Plascon-Evans is concerned, you will know two things with all due respect. The first one you will know is that even though ordinarily the version is determined on the respondent's version, that is insofar as factual issues are concerned and the potentiality for disputes of fact to arise. In this particular case, all the Commissioner says is factually, I exercised a power under 207. But the Commissioner, as a respondent in motion proceedings telling you that he did that, doesn't mean that the factual conduct under 207 is given legal certainty if, for the reasons I've told you already, subsidiarity and so on, he's not entitled to do that. What you also know, though, in urgent proceedings is that the Whiteman rule applies, that the court takes sometimes a slightly less stringent approach on Plascon Evans, but you also know, for example, that Media 24 Books, National Scrap Metal, both decisions of the Supreme Court of Appeal, tells you that where an explanation on affidavit by a respondent is so palpably implausible, it can be rejected on the papers. And we'd say that in this particular case, because there's no legal authority, Plascon Evans isn't something that will shift the legal issue in favor of the respondent if the respondent has no source of authority for that in the first place. It doesn't matter what he tells you, what he thinks the source of authority is. What matters is whether or not the court making the legal analysis determines that the source does give him that power or doesn't give him that power.
I think what you submitted is not answering the question that I raised. And the question is this. On the papers, the National Commissioner says, as a fact, what I did was sourced from Section 2.
Yes.
And you are saying what you did could not have been sourced from 2.
Yes.
Could have been sourced from disciplinary agency.
Yes.
Now, is that a factual dispute? Or not?
It's a legal dispute because it's the source of authority question. I mean, of course, both parties have different factual accounts of where the source of authority comes from, but the critical question is, what is the source of authority? And so that's why it's a legal dispute, not a factual one, with all due respect.
Thank you.